Very good day to all the students present and watching my video today. We are here to discuss the topic of classification of directors from the Companies Act 2013. Before I begin, let's have a brief idea about why we are discussing the topic in such a detailed manner. Because proper management of companies is a matter of public interest because, on the one hand, the interest of the countless persons in the capacity of a shareholder or an employee or a creditor is involved in the efficient working, and on the other hand, there are unscrupulous people who are bent upon to exploit the innocent members of the society. It is surprising that the law does not precisely define the term director. Section 2, subsection 13 defines a director as any person occupying the position of a director by whatever name called. This is not a satisfactory definition. So we can define him thus as a director is a one of those persons who are responsible for directing, governing, or controlling the policy or management of a company. Directors collectively are called as board of directors or board. The board of directors is the top administrative organ of the company. If company is the body, then directors are the brain of the company, and the company can and does act only through them. Section 291 expressively vests the management of the business of a company in its directors. The task of the shareholders is almost over with the selection of directors. Only the most important matters of the board policy may be referred to the shareholders for the decision at a periodical general meetings. In fact, the board is a supreme policy framing and decision making organs of the company. So thus directors are neither the agents, directors are neither the agents nor managing partners or proprietors nor trustees in the full sense of the term. They combine in themselves all these positions. In fact, they stand in a fiduciary position towards the company and at the best may be termed as officers of the company. And as officers, they may held to be responsible for their faults or omissions. So, classification of directors under Companies 2013 states the various types of directors as director is a person which is being appointed by the board of members unanimously with the help of a poll. Residential director. According to the Act, every company shall have at least one director who has stayed in India for the total period of not less than 182 days in the previous calendar year. Mind it, it's in the previous calendar year. The definition states that the director should be resident of India, which shows the director is responsible for the company and has not been making trips without any worry about the company. Next is additional director. According to the Act, the articles of the company may confer on its board of directors the power to appoint any person other than the person who fails to get appointed as a director in a general meeting as an additional director any time who shall hold the office up to the date of next annual general meeting or the last date on which the annual general meeting should have been held, whichever is earlier. This definition says that the articles of the company has authorized the board of directors to appoint additional directors whenever needed. This additional director will hold the office up to the date of next annual general meeting. Next, we have the alternate directors. According to the Act, the board of directors of a company may also authorize by its articles or by resolution passed by the company in a general meeting to appoint a person not being a person holding an alternate directorship for any other director in the company to act as an alternate director of the company during his absence for the period of not less than 3 months. This director is to be specifically appointed when the original director or the whole-time director is not present in the office due to any of the factors. Next, we have women director. According to the Companies Act 2013, some companies have compulsory now order to get at least one director as a women director. The list of companies who are required to get their directors as women are a listed company, any public company having turnover of 300 crore or more, or paid up capital of 100 crore or more. Independent director. Independent director basically means directors other than whole-time director or managing director or nominee director. There are certain reserved criteria for the companies to appoint independent directors. The companies need to have at least 2 independent directors. Like public limited companies having outstanding loan deposits of 4 crores or more, public limited companies having turnover of 100 crore or more, public limited share capital of 10 crores or more. Next is nominee director. Nominee director are the directors which are appointed in case of any of non-executive director not able to continue. Generally, they are appointed by the shareholders, but in some cases may also be appointed by banks or the central government, as the case may be. Next, we have shadow director. Shadow director is a new term which has been arrived, which means that person who is not officially appointed by the board, but he or she is given such advice to the directors which they are accustomed to follow, except when shadow director provides the same in a professional capacity. Small shareholder directors. A listed company may have one director elected by the small shareholders, may appoint upon the notice of not less than 1,000 shareholders or 1/10 of the total shareholders, whichever is lower when the small director which elected from a small shareholder. Next is terms of appointing the director. Only a natural person may be appointed as a director. A person may not be appointed as a director unless and until he or she is having a DIN, that is Director Identification Number. Person will receive a digital signature certificate, that is DSC, from accrediting authority for appointment as director. Every person nominated for appointment of director must submit his or her DIN and declaration that he or she is eligible for appointment as a director under Companies Act 2013. Everyone will give their consent to serve as a director on the form DIR 2 before or after his or her appointment. A person may not be eligible for the appointment of director if he or she does not qualify under subsection 1 of subsection 164 of the Companies Act 2013. One cannot hold the directorship of more than 20 companies at one time, including any other directorship positions. In addition, maximum number of public companies which a person may be appointed of director should not exceed 10. There is no disqualification prescribed under Companies Act 2013 for the appointment of a person as a director. However, Section 164 provides certain disqualification of the directors. Where a person is disqualified under 164, he or she will not be eligible for the appointed as a director in a company. So with this, we just gave a brief idea about classification of directors as per Companies Act 2013, which is equally important so that in order to understand the Companies Act or company law in a depth manner. So proceeding further slides will include about the certain doctrines, certain sections which are very much important for the Companies Act 2013. So the upcoming slides will detail more about Companies Act 2013. Thank you and have a good day.